Guys, loveys, I was just talking for 10 minutes. Oh, are you kidding me? I did the song, the dance, the 30-second countdown. I've showed 2 clips to who? Myself. Oh, Jesus, take the wheel. Thank you. Thank you for being here. Thank you for being late, a late night stream with me. Um, and let's start it from the top. I just looked up. I would have done an entire show, guys. Oh, it's a Monday. We're having a manic Monday. Okay. So, babes, I look up and it says it's showtime. And I go, babe, I've been showing. We've been showing here. No, I was incorrect. Okay. So, hi, everyone. I already said hello to you all. Hi, Cheryl. And hi, Jen. Jen said she went for a rage walk listening to EDB give her recap. Oh, I hear you, babe. Okay. Yeah. Yep. Yeah. I hear you, babe. Absolutely. Look at Sarah Berry. She says, it wouldn't be you if it wasn't this. Ain't that the truth? Okay. I also said, why do I have a Snooky Puff circa 2008? I don't know. It's what the gods willed. Okay. We need to just let it go and let God. And that is why we are here. We are together. And I love everything about you. Thank you for showing up, loveys, because listen, it's been a wild ride. We are here together emotionally today on, it is, what is today? March 10th, 2025. We are literally 20 days to trial, 21 days to trial. Wow. I'm blacked out. Are you? Okay. So I wanted to go over today just a couple of things, including the defendant's motion to exclude the purported expert testimony of the Commonwealth's proffered witness, Dr. We know I don't do names well. Let's go with Ezekiel Wolf. Okay, so not a crash daddy. All right. And request for a Daubert-Lanigan hearing. This was filed on March 4th, which was what day? The day your girl was in court. She was there. Okay. She was there. She was inside Norfolk Superior. I didn't get to watch Alan Jackson argue that beautiful motion to dismiss, but you may have seen me in a clip or two. Okay. What did I do? I snapped those little clips, snipped it for you so you could take a gander. Tell me what you think. This will be hilarious because I've already played them to myself.
May it please the court. The entire proposed testimony of Dr.
I can't. Okay. What a dork. Okay. Send me away. Send me somewhere. It might be time for a grippy sock vacation because your girl thought that Mr. Alessi may or may not drop his remarkable pro. It's what all of the attorneys are using now. Emily D. Baker was our queen who started it all. And so I just thought it was going to fall off of like the pew, right? For the court. So I like put my arms out instinctually. I'm like in mom mode. And I'm like, oh no, we can't drop that. Everything was fine, Kim. Just sit down. Sit the fuck down. Act normal. Okay, try to. I know it's hard. And that was a moment. Of course, you saw that at court. And then when I described looking at David Yannetti like a bowl of spaghetti on March 4th, last Tuesday, this is what I meant. How embarrassing. Let's get ready to laugh at me.
To the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile.
Stop it. Stop it. I'm blushing. Okay. What is the matter with me? Yeah, there's a lot. Okay. Let's not answer that. Let's try to be kind. But what a wild ride it was. And, you know, I will tell you, I will never forget the experience. Being in there was just, you know, very undescribable kind of, because we've seen it so long, and that courtroom specifically since pre-trial of number 1, trial 1, and now going into 2.0, it is just it's like surreal. So that's that. So this same day, all right? So last Tuesday, the defense files this motion. How did I not know about it? I don't know. I don't know. I knew it was coming. We knew that there was going to be the motion to exclude the neurosurgeon. And, you know, since I am a nurse and I've been doing this for 17 years, I figured, hey, this is my jam. This is where I do my best breakdowns of what's going on and try to keep us all on the same page and keep us moving forward to the best of our ability. So, with that being said, let's get into it, babes. So it says, now comes the defendant, Karen Read, Ms. Read, and respectfully moves this honorable court to exclude the entirety of the proffered purported expert testimony of Ezekiel L. Wolf concerning the medical cause and manner of death of the decedent, Officer John O'Keefe. Well, it just says John O'Keefe, but I put it in because it's habitual now. The mechanisms of injury and the conditions of the ground due to the weather conditions. Exclusion of the proffered testimony is compelled because it fails each of the 2 main prongs of the Daubert-Lanigan inquiry, qualifications and methodology. That is, Dr. Wolf is not qualified to render the opinion that he proffers. It is undisputed that he is not a pathologist, nor is he qualified to scientifically measure the material properties of the ground outside of 34 Fairview Road. Yet the Commonwealth is seeking to elicit this testimony from this Dr. Wolf, not our crash daddy, about the decedent's cause of death, the mechanism of injury, and the conditions of the ground due to the weather conditions. He thus fails the per se crucial qualifications of the Daubert-Lanigan standard. This failure is not curable. Stop. Okay. So as a neurosurgeon, Dr. Wolf lacks the requisite background, training, and expertise necessary to interpret an autopsy report because he is not qualified or board certified for a forensic pathologist. Thus, his expertise is limited to treating injuries rather than determining the circumstances under which particular injuries occur. Tell it to me slowly. Are you shitting me? Obsessed. What an incredible argument coming from the defense team. Why? Because 2 can play this game. They came for Dr. Russell like bats out of hell, and now they are going to pay the consequence, babes. Oh. Okay. We know that Dr. Renee Stonebridge was quadruple board certified. Let's do it. Uno, dos, tres, quadruple. Okay. 4 board certifications. We know that Dr. Marie Russell is duly board certified, right? She's a pathologist and an ER physician. Oh. And you're trying to get a neurosurgeon in that is unable to determine first the mechanism of injury that Officer John O'Keefe sustained to his back of his head, his cranium, and the conditions of the ground due to the weather. Okay, the meteorologist shouldn't even be opining to the ground because he's not a geologist, right? And I find it very interesting, babes. Like, listen, come here, come close to me. Okay, let me tell you something. I find it very interesting that the Commonwealth is now trying to tell us in 2.0, not in the first trial, but the second trial. Now they want to say that the ground was as hard as a rock. Well, what did your girl say from Jump Street? That's me. I'm your girl, if you didn't know. That Officer John O'Keefe would have had to hit some projectile, right? Either he was struck with something, or when he landed upon what? A rock, a boulder. There had to be, like, even if there was machinery and like metal, something had to be on the ground, because that is the only way that he could have had that 2.5-inch laceration to his skull that showed all the way down to his dura mater on his brain. Okay. So I say that to say this. They're now going to try to spin it that there was a rock, but the rock was the ground. And this is how we're going to combat it. Oh, she's thought about it. She's in it. She's ready. Put me in, coach. I'm ready to play. The defense team is going to say, okay, in my mind, okay, this, like, clearly I'm still a non-consensual intern. I know nothing. But there wouldn't have been a 2.5-inch laceration to the right side of Officer John O'Keefe's head had he hit the ground, because of the surface area of his head that would have made contact with said rock or said ground. Do you know what I'm saying? The contact of the back of the skull was greater than the 2.5-inch laceration. How do you get past that one, big boy? Okay. Mr. Wolf. Okay. You're coming in like a lion and you're leaving like a lamb. Is that what I heard? I don't know. But that doesn't make sense. The only thing that makes sense is that the back of Officer John O'Keefe's cranium, head, his skull was struck in that location with a perfect horizontal injury. And that was his fatal injury. So I opine that whatever struck Officer John O'Keefe in the back of the head was approximately 2.5 inches in diameter, in radius, rather. Okay? And the ground isn't going to cut it. It's not going to make sense. And we're going to have an expert to show that. Ooh, Sam Poop says, ICURN, also named Kim. You're a girl after my own heart. Hi, Sam Poop. I'm so happy you're here. Oh, and Bev's buttload of discretion says Mr. Wolf, second of his name, and that is how we shall refer to him. Okay? He is the wolf, second of his name. I appreciate you, Bev's buttload of discretion. Oh, there's a Bederow letter on X. Me. We'll get to that as soon as I'm done here. Oh, I need weekends. A wolf in sheep's clothing. Are you the best fucking chat that ever lived? Yes, you are. Yes, you are. Thank you, chat. Thank you, chat, for showing up and showing out with these comments. I'm obsessed. And Scott McGinnis says Hanky Panky is hoping the jury in the trial too buys his garbage. Agreed. But we're not going to let him pick up what he's putting down because you know what it is, Scott. It's garbage in, garbage out. Oh, where have we heard that before? And we know that the Commonwealth continues to try to pull the what? Wool over our eyes. We're not available. Thank you. Oh my gosh. You're a lefty? Shut the front door. I am a lefty. I'm a southpaw, babe. Yes, I am. Dominant hand. Mm. Oh, Kirsty Nursey. Kirsty Nursey is on alert saying if Sam is trolling Nurse Kim, we're still here for it. We like a troll. If you're a nice troll, just don't try to be too mean. Okay. So now next. We are back down. So we know that he lacks the training and the requisite for him to have the experience to interpret an autopsy, period, point blank. He never treated Officer John O'Keefe. Why? Because unfortunately, Officer John O'Keefe was pronounced at Good Samaritan Hospital at 7:50 a.m. on January 29th, 2022. So him even reviewing records would not be able to qualify him as needed for trial expert status in order for him to testify regarding that. In the ground, he's going to have to eat shit and bark at the moon. He's never getting that one. You know what I mean? Okay. So then the argument. So the Commonwealth fails to and cannot meet the burden to establish the requisite qualifications of Dr. Wolf, second of his name, to testify regarding cause and manner of the mechanism of injury. And it's important to know that although Dr. Wolf is trained as a neurosurgeon, the Commonwealth has failed to prove that Dr. Wolf has what? A reliable basis of knowledge and experience of his discipline to render an opinion in the field determining a manner and cause of death, identifying pattern injuries, diagnosing post-mortem hypothermia. Oh, let me make me small and this big. Sorry, babes. And require the expertise of a board-certified forensic pathologist, i.e., a neurologist is a clinician. Dr. Wolf's background, training, and experience is limited to treatment, not board-certified in forensic pathology. So the crucial issue is whether he is qualified to give that expert opinion, and we say, no, thank you. They refer to some case law from Massachusetts, which is always great. The mechanism of injury was a fall backwards. Oh, here we go. While Dr. Wolf may be able to provide expertise on how one would, quote, treat a brain injury, because what have I said since Jump Street as well? That Officer John O'Keefe sustained catastrophic brain injury, trauma. Catastrophic. Dr. Renee Stonebridge holds the key to his actual brain. She was the one who performed his autopsy of his brain. So it's incredible. And what she reported was devastating. Was the worst brain injury that I had ever heard someone recount on a stand. It was heartbreaking. So he might know how one would treat the brain injury or provide neurological care, but he lacks sufficient expertise in conducting the type of postmortem analysis of the cause of injuries and death included in his report. Now, we're going to get a little chunk here, babe. In his report, Dr. Wolf repeatedly exceeds the scope of his qualifications by reaching opinions on a cause of injury, namely, the mechanism of injury was a fall backwards. Bitch. Wolfie, shut the fuck up. The head injury was clearly inconsistent with any type of mechanism of injury, such as a bar or a hammer, or a car hitting him directly. Oh, well, isn't that interesting? Well, how's that grab your ass, guys? Because, I mean, like, not to be like dramatic here, but if it is from a fall backwards, Officer John O'Keefe sustained his fatal injury, and it's not from being hit by a car directly, then Karen Read isn't responsible for his death. Let me say that a little bit louder for the people in the back. Let me repeat it one time, like I'm I'm Mr. Alessi, right in front of Bev Canoni. If your own expert from the Commonwealth said that the head injury is inconsistent with any type of mechanism of injury, such as a bar or a hammer, you're full of shit up to your eyeballs. I'm a wound certified RN, sir, and I do know that specific length of wounds matters. And the surface area of a cranium and skull also matters, okay? But he says the frozen ground was, oh, nope, just kidding, such as a bar or a hammer or a car hitting him directly. Okay. Okay. So you just took the Commonwealth's theory. Okay. This is in your report, my guy. Wow. Wow. I can't wait for the defense to Daubert the shit out of you. If he fell backwards onto frozen ground and it created that injury, which it didn't, but if it did, then Karen Read is still innocent. We're freeing Karen Reads tonight, babes. We're freeing her. Thank you. Thank you for this report. So, anywho, he also says that he fell backwards. Well, that's inconsistent with reality, good sir. Okay? Because this is what I want to tell you. I'm going to give you a little ditty about Jack and Diane. No, I'm not. I'm going to give you a little ditty from Kimmy. And it goes a little something like this. A man falling from a standing 6'2", 217-pound Officer John O'Keefe, 6 feet to the ground, could not, would not, shall not ever be responsible for that injury, for that catastrophic brain injury. Oh, okay. Because any of us that have fallen as adults, have any men, do I have a man in my chat that is 6 foot tall? Have you fallen? Okay. Have you fallen on a hard surface? And you know what you didn't do? Pass away. Okay? And these are the things that are crucial that we hammer this home, okay? So ultimately, his death resulted as a combination of the brain injury and his hypothermia. Correct. Correct. We agree. But you know what it wasn't caused from, good sir? It wasn't caused from Karen Read, a side swipe at 24.2 miles an hour for 62 feet in a straight line that she managed to strike Officer John O'Keefe directly in his right upper extremity, which therefore ergo spontaneously combusted polycarbonate taillight, pirouetted him, and then he landed on ground and had such a catastrophic brain injury that he succumbed to that injury. It was fatal. Nope. 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 This is not a science fiction novel. Now, had you told me, and I've told you all this before, let me come close again. She's talking shit. Now, babes, had it been you and me, and let's say somebody fell 3 stories from off a ladder, right? And they fall onto a curb, smash. Sorry. I apologize for my verbiage. But if you were to strike your cranium, your skull on a curb from, 2-3 stories, of course. What is that? Physics. Hello. Is this thing on? Boop, boop. Right? But from a standing to falling situation to the back of your head, It could not have occurred. It is not inconsistent. It is inconceivable medically. Hi, babes. Are we free and Karen Read tonight? Yes, we are. Let's do it. Let's put a little something up because you know what matters. Here it is. One time. Oops, a little bit longer. Is this going to free Karen Read? I believe it may. I believe it may be on the correct path. Thank you. Thank you for asking, biblical scribe. And then I also ask this. I ask this humbly of the Commonwealth. What the fuck are we doing?
Suspicious, don't be suspicious.
John Ralphio?
You know what I'm saying? Okay. So then, let us travel. Okay, so we know that he has no experience in diagnosing hypothermia from an expired body and no experience identifying pattern injuries. Thank you, pal. But he should not be permitted to consider with speculative evidence. And Daubert requires that the court ensures that Dr. Wolf, the second of his name's conclusions, have a reliable factual basis and are limited only to matters precisely within his field of expertise. You'd fucked with Dr. Russell for 2 days. Oh, 2 full days. Okay. And, you know, may the force be with you, good wolf, because you're about to get fucked on the stand when these questions are asked of you. We get some more case law. Then Dr. Wolf ventures well beyond his qualifications as a neurologist and attempts to step in to the role of pathologist and pediatrician to opine that the frozen ground was enough, that when Mr. O'Keefe fell backwards, his injuries were sustained, or that, quote, his death resulted as a combination of the brain injury and his hypothermia. Well, okay, I understand what we're saying here, but I actually think he's right on that. He absolutely died as a result of the combination of his brain injury and his hypothermia, and that is consistent with Dr. Scorty Bello, her findings as well. It was that blunt force trauma to the back of his right occiput and the combination of the hypothermia. Oh, Jen Altman. Hi, Jen Altman's in the chat. That's fun. Says, my 84-year-old dad fell on Sunday and hit his head on the sidewalk. He's beat up, but fine. John did not hit his head on grassy snow. First and foremost, I'm glad to know that your dad is okay. And I'm so sorry that he had a fall. And I know what that's like. My dad is 76 and he fell. And when he had the pneumonia, and then he had to go to rehab. So I know it's our aging parents is, you know, so difficult to see, but that's another example. My dad was in the house, but Jen saying that her dad was literally outdoors and hit his head on a sidewalk. Okay. And at 84 years old, he was still able to, you know, be treated and survive that. So that's huge. And then we are going to bop. Sorry, babes. Do you know how I get sidetracked? Okay. I'm going to do that. And so the court did not reach the other prong, methodology, of the Daubert-Lanigan inquiry to exclude Dr. Wolf because the failure on the qualification prongs alone warrants exclusion of his testimony as to the mechanism of injury and cause and manner of death. Even if the court proceeds to the methodology prong, the proposed testimony of Dr. Wolf fails on this prong as well. And we know what methodology is. We're talking about patterns and all of that jazz. And that I wanted to go, here it is, right? Dr. Wolf claimed no scientific or technical basis for his opinions. He reviewed various documents and exhibits listed in his report as the basis of his conclusions and offered no explanation of the methodology of his analysis. Moreover, in reaching his opinions and conclusions, he ignored the precise information that must be considered in determining the cause and manner of death. Namely, he fails to address or acknowledge the abnormalities, bing, 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 present in the decedent, and fails to acknowledge any evaluation of the toxicology report, both of which are critical steps that would be considered by anyone trained in forensic pathology in determining the cause and mechanism of injury. That's interesting. Okay. Oh, we're going to go toxicology. Okay, babes. Do you remember when we talked about the vitreous humor behind Officer John O'Keefe's eye when after he was pronounced it was post-mortem? Do you remember? And his BAC post-mortem blood alcohol content was 0.29. And that was on its way down. Wow. Okay. I remember that. I think I remember that. Do I remember that correctly? I remember that. Yeah. I did a video on it on TikTok. Oh. But that has a place here. It matters. You know what I'm saying? Okay. So the format of the forensic pathologist approach differs from a treating physician. A forensic pathologist investigation begins with death and does not conclude until the results of the autopsy, histology, toxicology, and ancillary studies have been completed. In clinical medicine, no finding or laboratory value is interpreted by the pathologist in a vacuum. Ooh, it was 0.28. It's 2 hours behind. Oh. That's a very high. That's a very high BAC, babes. If you are asking what a normal like legal limit is, but that's for driving, that would be, 0.08. Anything above that, you can't be driving. And, there was the extrapolated data that came from a non-consensual talk screen during a Section 12 that Karen Read underwent, which I still would like that to be challenged. I would really like that to be challenged, because if you can't find consent where Karen said, you can take my blood for a talk screen, then they shouldn't have done it. Because there was no indication. She was not under arrest. She was not suspected of a crime, and she did not consent to anything but mental health services. So her BAC at, 7, whenever she gets there in the morning, 7 something, is 0.008. She's right at the legal limit. They do an extrapolation data based on information that is given by the Commonwealth and not by what Karen has said. So had Karen Read gone back to Officer John O'Keefe's house at One Meadow and she had a nightcap because she's pissed at, she's going, John, she's leaving him messages and she's like, what the fuck? And she has a Beveragino, then that wasn't taken into account correctly. And the range from 0.13 to 0.29 would have been incorrect. Because they said last drink was at the waterfall. Oh, okay. So then further, this section, the death certificate, is what's most often understood as other significant conditions. Here, Dr. Wolf neglected to acknowledge the entirety of this section in his report. Ultimately, the touchstone of admissibility is reliability. And in conclusion, Dr. Wolf is not a pathologist or forensic pathologist, and his proffered testimony and methodology is outside his scope of expertise, thus failing both prongs of Daubert-Lanigan, and Ms. Read respectfully requests The court exclude Dr. Wolf's proposed testimony because of the Commonwealth failed to and is unable to satisfy the burden of establishing proposed testimony that meets the requirement of Daubert versus Merrill Dow Farms in 1993. And this was submitted respectfully by the defendant Karen Reed and her attorneys, Alan Jackson. We've got David Yannetti, and then Robert Alessi did a support in the an affidavit. To support the defendant's motion to exclude the purported testimony of Dr. Wolf. Okay, what are you saying, Mr. Alessi? Okay. No, he has no expertise or experience or licensing. We knew that. And after reviewing the materials and assessing other discovery, Dr. Ezekiel Wolf does not have the training and experience. Great. Thank you. Here's an attached exhibit A. Oh, and his CV is exhibit B. Okay. After reviewing Dr. Wolf's report, his opinions are not scientifically based and are misleading to the jury. Okay. If admitted, these opinions would significantly prejudice Miss Reed and deny her constitutional right to a fair trial. The Commonwealth has failed to meet its burden. We know that you feel that way, and will assist the trier to, okay, yep. And the defense asserts that Dr. Wolf is not a forensic pathologist, which is like, that's fact. Facts matter journalism. And does not have sufficient education, training, and experience in determining the cause and manner of death and mechanism of injury. Perfect. In fact, Dr. Wolf is a clinician who lacks the necessary licensing and credentials to render such an opinion. Thank you, Mr. Alessi. We appreciate you. Okay, so he's just saying, hey, boo, I need you to Daubert the shit out of this. I love it. And Billy Watson knows that what? Alessi does his homework. We know this. So this is big doings, babe. That was the first time I read that was with you, okay? So that was all off the top of the dome. Bear with me. But that is very interesting that the defense is saying that this neurosurgeon can't come in and he can't testify to specific areas, which I think that Judge Cannoni, if she's not in a very mean Polly Pocket type attitude, that she would need to agree. She would need to concur and say, okay, boo, you can definitely testify to what you want to testify to, that you could in theory, but I don't know what he would testify to because he wasn't treated. Yeah, I don't know what he's going to be able to testify to. And I would really like to know, do you remember when Hank got up, babes, and he goes, oh, if Karen had acted sooner, allegedly, sorry, excuse me, then he could have gotten burr holes. And I was like, please stop talking. Stop talking immediately. Okay. Honk the horn. Stop it, Hank. Stop talking. You don't know when burr holes are appropriate. And your neurosurgeon, if he didn't treat him, I wouldn't be saying that either. Hold on, babes. Thank you, Kelly Fairfield, for becoming a new member consensually. Okay, now I am going to tuck and roll. And absolutely, Pokemon says, no, don't stop. Oh, and Hanky Can't Do That by Bob Alessi says, Kim, you're going to love the Bederow letter to Chief Rafferty. I'm ready. Okay. And yes, absolutely. We're about to, it's happening. Okay, now, babes, bear with me. That is what I wanted to go through with us. This is going to be the first time I also see this Bederow letter. Oh, am I going to be able to do this? I'm a moron. Okay, share this tab instead. Go live back at your home. Nope. Oh, what is tickling my throat? I'm so sorry. Okay. All right. And now I'm showing this, but how do I make it? Can I get rid of this? Okay, I'm going to do that. And then I'm here, and now I'm going to do this again. Oh, guys, this is horrifying that I can't do this correctly. All right. Is this it? I think this is it. Yes. Yes. She's getting better. She's making progress. Ooh, by the by, babes, quick question. If you're interested and you are available, I'm doing a Nurse Kim fundraiser for our best friend from out of town, Karen Reed. And I'm doing $12 for 12 experts. And we went over the expert of the Commonwealth, right? But we know that the defense intends to call 12 experts total this trial. This is a shit ton more than we had at 1.0. So I was thinking, if it's possible, if you have it on your heart, if you have it in your spirit, and you feel like you would like to, help our girl and free some Karen Reeds, then the link is pinned at the top of the YouTube chat, I believe. If it is not, I will literally be pissed off because I tried. Okay? I don't know how I'm screwing around with all that stuff. Oh, this is wrong. I'm not even, oh no, I am in the right place here. Okay. So I'm going to be reading those, like anybody who does do the 12 for 12, just write Nurse Kim so that I can say your name at the stream this weekend. And then, oh, babes, I'm doing a giveaway. What are we doing? I'm going to be making, oh, she's arts and crafts and she's an Etsy bitch. And no, an Etsy, not an SD. You know what I meant. And I'm going to give away Nurse Kim pearls to clutch our pearls and clutch our butts together. Okay. So now let's find this letter. Where does the letter live? Who posted the letter? Did Mr. Bederow? Hello, Anthony from Ohio. How are you, lovey? AJ's Roundtable. Oh, what? Where is my? Okay. How do I find where everything lives? Oh, that's terrifying. Okay. No. Natick police. Do we know Mia? Oh, TB. He did it. Oh, okay. TB did it. Okay, I'm doing it. I'm gonna look him up. Oh, is she gonna look him up? All right. Turtle and a boy. He's both. Four hours ago. Is this it? This must be it. Oh. Okay. What? Wait a minute. This can't be it. Is this it? What am I doing? Okay, no, that's right. This is TB. Okay, that's his. No, that can't be it. Oh, here it is. Oh my gosh, Kimberly Jean, find it. All right, here we are. It doesn't let me attach the PDF, so here are the screenshots of the first 4 pages of the letter. 4 pages. Oh my. Mr. Bederow is not messing around. To Helena Rafferty. Are we blacked out? Get your pearls. Hold, please. Pearls are needed. Okay, Bubbles. Okay, you gotta go. You go quick. Quick. You gotta go pee-pee? You do the pee-pee house. Okay, you go. Good boy. Good boy. Good boy. She's here. Okay. Oops, I just had to take Keno out to go do a whiz. All right, Nurse Kim Pearls, we've got the email up. I'm going to make me small, going to make this big. Give it a whirl. Here it is. Via email, March 10th, 2025. Dear Chief Rafferty, from the law office of Mark A. Bederow. Shut up. Okay. Dear Chief Rafferty, along with my co-counsel, Timothy Bradel, I represent Aiden Carney, who is scheduled to appear in the Stoughton District Court on March 18th, 2025, in connection with his alleged witness intimidation of Canton Town Selectman Christopher Albert on March 4th, 2025. Oh my gosh, it all happened the same day. I'm in the court. The guy was getting filed for our neurosurgeon, and there was the CF McCarthy's / D&E incident. Okay. Outside of D&E Pizzeria, which is owned by Mr. Albert. The matter is being investigated by Detective Brian Tully. Shut up. Stop it. Why can't we get somebody else? Is there no one else? Do we have the same 4 assholes just walking in circles, just circle jerking around town? I know that there is at least 12 of them on that Norfolk DA team. So I don't understand why we have to use the same names all the time. Oh, Lord. I write to formally request that the Canton Police Department, CPD, commence a criminal investigation into Mr. Albert for apparent violations of MGL 272, Chapter 99, interceptions of wire and oral communications, both generally and regarding the interception of Mr. Carney's oral communications outside of D&E on March 4th, 2025. As detailed below, there is conclusive proof that Mr. Albert, A, repeatedly intercepts oral communication of people outside D&E without their, I bet it's knowledge. Oh, actual knowledge. And B, unlawfully possesses an intercepting device with the intent to commit unlawful interceptions. Bitch. We just said that Chris Albert is wiretapping. Oh. Clutch him. Are we clutching? What? To the extent that the CPD is incapable of conducting a fair and unbiased investigation due to A, Mr. Albert's position as a town selectman, which grants him oversight over the CPD, that is true. They do all of the budgeting. They do everything. They're in charge of well, there is the audit committee in theory, but like they did the initial vote. Okay. Scoobity bop. Okay, your term of employment and compensation, and B, the aggrieved party bringing this issue to your attention is Mr. Carney. Mr. Albert's brother, Kevin Albert, serves as CPD detective and or CPD's vigorous yet unsuccessful attempt to prosecute at least 10 individuals for allegedly intimidating Mr. Albert by exercising their First Amendment right to criticize the prosecution of Karen Read. And they're public people. If you have a public position, right, and you are a selectman or a police officer, you are open to criticism more than a civilian at all times. Oh, I request that you promptly notify me whether you intend to refer this matter to a law enforcement agency. The relative facts. Okay, D&E is located on Washington Street in the heart of downtown Canton. I'm sorry. If anyone's been to Canton, the heart of downtown Canton, I can't. One fucking street. I digress. Oh my. Therefore, as the main downtown there thoroughfare, Washington Street, and then he says the Mr. Carney is a vocal critic of the Karen Read prosecution and has criticized CPD, MSP, and Mr. Albert, among others. Yes, criticize. He has. As you are aware, acting upon Mr. Albert's claims of, quote, emotional and, quote, economic harm, the CPD dedicated staggering resources to prosecute the so-called, quote, Canton Nine for expressing their dissatisfaction with the Read prosecution by protesting across the street from D&E, and Rich Schiffer, who left several rubber ducks around various locations in Canton, which criticized the Read prosecution. Charges were declined or dismissed against all of these individuals after courts concluded those targeted for prosecution by the CPD were exercising their First Amendment rights. Bitch. That is a bitch slap if I've ever felt one. Mr. Bederow. Take him to church. And then we have, Mr. Albert contacted the MSP claiming that he was intimidated, quote, intimidated by a mother and daughter placing rubber ducks near D&E. Not surprisingly, those matters were also dismissed on First Amendment grounds. Next. Babes, this is juicy. Page 3. Contains the heavy, we're talking about the thoroughfare, right? In downtown Canton. Contains the heaviest pedestrian and vehicle traffic in Canton. D&E utilizes 2 Waze cameras, one of which is perched outside, aimed directly at Washington Street and sidewalk. There are no signs or notices posted at D&E warning customers or passerbys that their private oral communications are subject to being intercepted and recorded. I'm sorry, babes. Are you wait a minute. I think this is just processing with me. Are you telling me that Chris Albert and D&E Pizza aren't hearing what is going on in their shop, which I believe they would have the right, but what is going on outside in their public, like on the sidewalk, when people are walking up and down in Canton and are just like shopping and doing and eating at, wherever, CF McCarthy's, going across to the waterfall, whatever they're doing there, that he has access to every United States citizen's thoughts and words that are said on a fucking sidewalk. Oh, that's assault. Okay. So, as reflected in Detective Tully's March 5th, 2025 report outlining Mr. Carney's alleged witness intimidation on March 4th, Mr. Albert acknowledges that D&E's exterior camera intercepts and records audio from anyone within its range. Oh, the plot thickens. See Exhibit A at page 2. The camera located at the exterior of the building is audio recorded. See Exhibit A at page 2. The camera located on the exterior of the building is audio recorded. Okay. Audio is captured by an exterior camera. In other words, Mr. Albert admits that he can and does intercept and record private oral communications made by anyone in D&E's proximity, irrespective of their ignorance to the fact they are being eavesdropped or recorded. Oh my. We are physically clenching our butts. Do your Kegels, girls. This is happening. Mr. Albert alleges on March 4th, 2025 at approximately 10:20 p.m., he listened from the safety of his own home, from his couch. Okay. Where was he? Was he snug as a bug in a rug? I don't know. And to this, I'm not going to say this right, surreptitiously recorded video of Mr. Carney addressing Mr. Albert and his son Colin about their Read testimony. See Exhibit A, page 2. Mr. Albert alleges that he was, quote, very upset about Mr. Carney's statements, although not relevant to the issue of whether Mr. Albert is in violation of Mass General Law 272, Chapter 99, Section 99. The video depicts Mr. Carney facing an interior camera rather than the audio-enabled exterior camera, which is located at the far end of the property. Okay, I'm blacked out. Okay, so Mr. Carney is facing the interior camera rather than the audio-enabled exterior camera, which is located at the far end of the property. Okay. On March 5th, 2025, Mr. Albert spoke to Detective Tully at 8:15 a.m. Detective Tully completed a 6-page report. Oh, that enrages me. A 6-page report on T-Rex hands and rapping. And we didn't have a 6-page report on Officer John O'Keefe. That, like, anyway, and sought Mr. Carney's custodial arrest for witness intimidation within 49 minutes of learning about the incident. The Stoughton District Court denied the request for an arrest warrant. Well, thank you, Stoughton District Court. Doing the right thing. Okay, applicable law. We're into Mass General Law 272. Babes, I can't look that up. Can somebody look up Mass General Law 272, Section 99 requirements? Oh, no, it probably will say it right here. All parties for the recording of oral communications. The statute's preamble details the legislator's concern with the uncontrolled development and unrestricted use of modern electronic surveillance devices, which, quote, pose a grave danger. Oh, grave danger. Bitch, are you shitting me? That's in this law? Grave danger? Oh, who wrote it? Was it Judge Bev Canoni? Was it one of her ancestors? Was it one of the witches who wore heels in 1692? I don't know. Well, that couldn't have been because we didn't become a country till 1776. Shut up, Kim. Okay, accordingly, a stated legislative intent of the statute is to ensure that the secret use of such devices by private individuals must be prohibited. And there's emphasis added. Oh. Emphasis is big doings in the Commonwealth, okay? When they emphasize the shit, that means like, hey, bitch, that's a no-go. Stop, do not pass go, do not collect $200. Uh-oh. Oh. Oh, sorry, guys. I just got a thing. Perfect, Lovey. I'm going to post that. Thank you, Jen Altman. She's in the chat. That's fun. Then it says, unlike the Fourth Amendment, Mass General Law 272, Section 99 provides protection to an aggrieved person, a non-consenting recorded party, because in Massachusetts, we are a two-state, two-party consent. That means I call you boo, and I say, I don't know, like Billy Goat Gruff was dumb or something. Like whatever I say that I didn't tell you that you could record, you cannot record it. It can be the dumbest thing. I could say that I hate Tom Brady, okay, which would be a lie, okay? But if I said it and you recorded it without my consent, we're fucked. You're fucked, not me, because I would never do it. Then it says that the individual does not have a reasonable, even where that individual does not have a reasonable exception of privacy. So consequently, a recording made on a public sidewalk or thoroughfare may violate the statute. Secret recordings made on a cell phone in public places, babe, still held illegal. Under the Massachusetts statute, the recording is made secretly and thus illegally. Oh, shit. Oh, I should have read this privately. I'm having a reaction. Okay. Wowza. So this means that Mr. Albert has no absolute right to record oral communications made by someone positioned on a public sidewalk or street within the range of D&E's audio camera. Yet, this is precisely what D&E's exterior camera is set up to do. Mr. Albert's blanket audio recording of individuals outside of the D&E without their actual knowledge constitutes a felony under Mass General Law 272, Section 99C-1, which states that any person who willfully and secretly audio records another without, quote, prior authority by all parties to the communication is guilty of a felony. Significantly, the statute contains an evidentiary presumption that, where's the next? Oh, babe. We're getting page 5. Hold your horses. Okay, hold on. Do we need a minute? Let's talk to each other. Okay, how we doing? Hi. That's interesting. Is it? Right? Oops. Says, shows how dumb they are. Yes, you be you, I be me. Billy Watson, very dumb. Is that... Megan Easton says, is that a civil suit I smell? Is that a class action? Is what I smell. Oh. Okay. Oh, and Kelly, if Chloe bit you must acquit, says, I'm on the frickin' moon. Babe, I'm spinning out on the rings of Saturn. Currently, I'm going to have to try to get back into our orbit, but let's continue. Page 5, proof of the installation of any intercepting device by any person under circumstances evincing an intent. Evincing, is that right? Am I an idiot? Yeah. An intent to commit an interception, which is not authorized or permitted by this section, shall prima facie evidence of a violation of the subparagraph. ID. Simply put, Mr. Albert's installation of a recording camera, while aware that it would record audio without the actual... Oh, I heard Kino. Bubbles? Oh, okay. Let me just get through this. Of the intercepted parties conclusively establishes that he is in violation of the statute. Additionally, separate and apart from the March 4th, 2025 incident, Mr. Albert's mere possession of the camera with the intent to audio record another without his or her agreement constitutes a misdemeanor under the general law, Section 5. Other factors warranting an investigation. Oh, Mr. Bederow, stop it. Stop going this hard. I can't. It is essential that the CPD be even-handed in determining whether to investigate potential criminal violations without regard to any relevant party's views on a controversial matter of public concern, such as the merits of the Read prosecution. Mr. Bederow, let's stand up. Let's stand up. That's incredible, sir. Exactly. Here, there is overwhelming evidence that the town selectman and longtime business owner is violating the law and flagrantly invading the privacy interests of anyone who makes oral communications within range of D&E's exterior camera. Failure to investigate here will lessen the public's confidence in the CPD's ability to apply the law in an unbiased manner and to protect the public without regard to a possible offender's prominent political status in that community. His family's close relationships with the CPD and his involvement in and enthusiastic support of the prosecution of Karen Read. I'm tripping. I'm extraterrestrial. ET phone home me, bitch. Okay, page 6. We're going to get through this together. Moreover, Mr. Albert's prior dissemination of records from D&E's cameras to mock supporters of Karen Read. At the same time, he has repeatedly and unsuccessfully accused several of them of intimidating him is troubling and he supports the need for it supports the need for an investigation. On September 26th, 2024, Mr. Albert arranged for the public release of a video from one of D&E's cameras to humiliate an individual who had the the temerity to peacefully exercise her First Amendment rights by writing FKR, Free Karen Read, on her vehicle window while it was parked in front of D&E. Mr. Albert recorded himself watching this video. Bitch. He referred to the woman as a loser, and that's not how he said it. He said loser and disgusting bitch. Rude. You are a rude, bald prick. And then instructed someone to take her picture. Within a few hours, this video was provided to Catherine Peter, who promptly posted it on X. See Exhibit B. It stands to reason that if a town selectman is is undeterred from making such inappropriate comments about his constituents or town visitors, and he is brazen enough to publicly disseminate this video to the name of to name someone exercising her right to free speech, he is more than willing to secretly intercept and record oral communications made by others outside his place of business. For these reasons, we request that the CPD investigate whether Mr. Albert's interception of oral communications of Mr. Carney on March 4th, 2025, or of anyone else within range of the cameras located at D&E violates Mass General Law 272, Section 99. Respectfully, Mark A. Bederow, CC Tim Bradel, and Aidan Carney. Okay, guys, I just want to tell you that Mark Bederow has full-blown Uno reversed the shit out of this. I'm sorry, did you see that coming? So everybody's over at CF McCarthy's. They had a gift certificate, right? They're eating a little suppy, okay? They're having a little supper. A meal of food is what they would say. They come out, best decision anyone's ever made? No. Okay. They were singing Cher the next day. If I could turn back time. I know they were. Okay. But did we just find out some shit? Did we just, by a poor decision, end up uncovering the fact that Chris Albert has been illegally wiretapping anyone who has walked by his establishment since fucking Christ knows when? Since he put up his cameras and has been doing this illegally for an extended period of time and talking all the shit about anyone who believes that Karen Read is innocent. You can believe that Karen Read is innocent and still go anywhere you want. There are detractors that will try to tell us, like, you don't want to do that, or we're going to say this about you. We're going to dox you. We're going to be horrible to you. We're going to report you to your nursing license board or to any license that you have. But I'm allowed to have an opinion. You know what the fuck you're not able to do? Wiretap. So I hope that you're ready for what's coming next. Because I think you're in for a bit of a bumpy ride. And you deserve what's coming your way legally. Because you have chosen, allegedly, to not adhere to any laws. And that shows, in my opinion, guys, that the Alberts have always been above the law. That's another example. And there was no fear of any consequence, but rather that they would get all of us in trouble, not them. That was a lot. That was a lot. We are good. Hi. How you doing? Is everyone okay? Talk to me. Tell me everything. Oh, Mac Dickles says the town clerk engages in felonious acts. And Andrea Clark says that's not allegedly, those are facts. And Thomas T was kicked hard in the colon. Okay. And you know what? And that's why I clench my butt, babe. You know what I'm saying? If you take a hit to the colon, you're not well. And yep, there it is. And Tully did the report, shaking my head. Marianne, I know, right? Like, can't we find a friend? Can we fucking phone a friend? Does anyone have anyone that like is not knee deep in clams down the Cape with Bev? I don't know. You know what I'm saying? Oh, Karen says that oral is a felony in Canton, and I would like to think that it is not. I'd like to think that consensual oral could be, definitely something that both parties could enjoy, And now that's hilarious. Kelly, if Chloe bet you must have quit, says Bederow is now law Jesus. That was wild. We just went on a journey together. Okay. I did not know that was going to be that. We read it together for the first time. You all, thank you for sharing it with me and telling me this. What a night. What a turn of events that I believe not many of us saw coming. So that is wild. I do want to share one other thing with you guys while you're here with me because I love you. Oh, what am I doing? Okay. Is she here? Is this it? Here it is. Oh, make it big. This is what Jen was sending to me. But can it get big? Okay. Oh, I'll make me small. Sorry, babes. This is the Waze camera of Canton.
You're like a dog with a ball. I can't. Oh my God,
Wait, come here. You gotta do the where it's my arm and you talk. I said, what have you done? Peter Burger says, oh, I'm missing you. You look at me with alive today. And would you didn't drive drunk? Chris. Why did you do that, Chris? Chris, why did you tell the jury that you got home at 12:15? Why did you say that you went upstairs and that there were 15 minutes before taking off? And then Colin came home. It seems Colin didn't make it home until at least 12:45. It was Colin, Chris. I just want to know. I mean you don't want to. I just want to know why it took Colin so long to get to your house. Why, Chris? Please tell me why. Okay? That's all I want to know. Y'all Colin did it. Okay, you can tell me. You can tell me, Chris. You can tell me. I know you didn't do it. But I don't want to scare you, okay? Tell Jill to keep her hands to herself, too.
Okay, everyone be nice.
Yeah.
Hey, no, I'm gonna send you that. Don't come on. I love you both.
Okay, babes. Now, I can't believe how sensitive Mac Dickles had like such a great point. How sensitive that audio is, right? We heard everything. And your little T-Rex arms, although childish, sophomoric, if you will, it's dumb. They're dumb boys. Okay? This is not threatening. This is not fighting words. And I don't quite understand how it has come to this point, right? Like, how have we gotten here? And again, there's somebody said, how much is that turtle in the window? All right. How much is he? The one with the little tail. Oh, and Jam Cracker said, Chris will say, I didn't know it was illegal. And then he needs to be told ignorance of the law is no excuse, just as the rest of us have been told at one time or another, maybe. Love you, Kim. Jam Cracker, I totally agree with you. Like, you can't, ignorance is not bliss here, right? And you can't play dumb. Chris Albert is not an 18-year-old kid. He's not a 17-year-old kid. He didn't go to a house party and drink, beer somewhere and they got caught. You know what I mean? Like, many, many moons ago, you could do that, like, 20 years ago. But this is a completely different category. You are not just a public person who has a business in the town, you also are a selectman who stood right outside of this very business and told Turtle Boy in the summer that you would kick his fucking ass up and down the street. What? And his dumb fucking turtle arms, or not turtle arms, T-Rex arms are a 6-page report from Tully? Get a life. Stop it. Stop it. Huh. KCL knows there is a double standard. I agree, babe. Now, the other thing I wanted to share with you that I thought was pretty cool, if you ask me, was that me and Dave were invited to go tonight to Boston for the ID, the investigation discovery, the premiere. And we didn't go. We're losers, but we didn't go. But it was super cool that we were thought of. And I got to see this little clip from that was posted today, and I was obsessed with it. And I know that it is going to be over 200 hours. Oh, can you hear me? Did I go away? I'm sorry, babes. Karen did 200 hours of unprecedented access that she gave ID. Okay. Now, if we remember back and turn back the hands of time for Variety, not for Variety, nope, for Vanity Fair, she gave Julie Miller 3 days. It was, 3 days and 3 nights, 72 hours, all access, non-negotiable. It was incredible. ID got 200 hours. And Karen says in this clip that this is her testimony. And when I tell you that when Karen talks to any outlet, I know that people want to use this against her. And I understand that it may not be, I guess, the best thing that has happened, right? Because they're going to take a word that she says and they're going to try to spin it on her. But the fact that she has been able to do this type of press, there is no one else in the United States of America in the history of any trial that I can ever recall, that I've ever seen in my life. And I for certain have never been following or close to something like this ever before in my life. But for Karen and her team, the Read team, Robert Alessi, Liza Little, Alan Jackson, David Yannetti, the Read team, they are all for her doing anything that she wants to be able to get her side of what has happened out. And, you know, of course, this was before first trial when they were contacted. But now she's going to fight for her life in a second trial, less than a month away, 20 days out. And I think that Karen speaking to these outlets shows her innocence, in my opinion. I've never seen anyone who I thought, you know, did something very terrible or bad that was like, let me keep talking about it. Maybe they did for a week, right? Like if you go back and you think of like Scott Peterson or that oh gosh, what was his name? The father, and he had the two, Bella and Celeste and Shanann Watts, Chris Watts. Okay. Yeah, he tried. He thought he was going to be a devil and try to get sympathy for a week. We're going on 3.5 years. And Karen's still able to have these conversations because she knows that she didn't do this. She never struck Officer John O'Keefe with her car, and her car never struck Officer John O'Keefe. Okay. Sorry, that was my spiel. And I also, guys, this just was popped up, and this is at the top of my page. And it is, it just in case you, where am I? Oh, I'm sorry, babes. In case you came a little later and didn't hear me, I am doing a fundraiser for Karen, and it's $12 for 12 experts. And we're going to free Karen Read.
Boyfriend John O'Keefe. Prosecutors say she hit him with her SUV and left him for dead in someone's yard as a snowstorm.
Sorry, I'm going to make me small.
It's the trial that captivated millions and divided a community.
Now I'm being charged with murdering a Boston police officer. I could face life for second degree, life in prison. I still can't believe what's happening to me.
Karen Read is accused of murdering her Boston police officer boyfriend, John O'Keefe. Prosecutors say she hit him with her SUV and left him for dead in someone's yard as a snowstorm rolled in.
So did you drive your car into John?
I did not drive my car into John. Didn't reverse it. Did not hit John with my car.
Now, a new ID docuseries, A Body in the Snow, the trial of Karen Read, taking viewers behind the scenes of the contentious trial that ended with a hung jury. Read now facing a second trial next month. Director Terry Muir telling us Read reached out before her first trial.
Is unprecedented that we had to Karen and her defense team.
Following her for all of this time and having so much access, what surprised you the most?
I think I was mostly surprised by how involved Karen was in her defense. I think that's very, very unusual. She was there for every single minute. And, you know, she said, what else am I going to do? I'm fighting for my life here. I want to be involved.
The cameras following Read for more than 200 hours at her home, in the car, going inside her meetings with her lawyers, even in her team's so-called war room, as they prepared and put on their case, poring over video from police body cameras, as well as evidence they collected to put on her defense, saying that she's victim of a corrupt police trying to cover up, she said, was a fight that led Keith dying with his fellow officers.
Why are you doing this film?
This is my version of testifying. Doing this film is my testimony. This has happened to me. And, you know, I know what happened between John and me. I know what happened in our life and time spent together before then. I know the events of that morning. I know what I said. I know what I didn't say. And I haven't been able to say it. It's incredibly frustrating.
Karen Read's retrial is expected to start April 1st. It's going to look a lot different than the first one. There's a new prosecutor. Read has added more defense attorneys. There's potential new evidence. A Body in the Snow. The trial of Karen Read premieres on March 7th on Max.
All right, babes, can you hear me? Just making sure. Is she back? And then do I make it small like this? Are we getting better at the desktop? Stop it. Don't get too excited. Okay. And
My name is Karen.
so that is it, babes. That is where I wanted to stop with us for tonight and tell you all that I love your faces. You are the best community. You are fighting for justice. You are fighting for truth, and we will keep standing up every single day. You are the best to ever do it. We're going to keep fighting for Karen. Okay. We keep fighting for the Reads. We keep fighting for Officer John O'Keefe and his family as well. All right. I love your face. I'll talk to you soon. Bye, babes.